Good. I see Mr. Bergman. I see Mr. Menzies. We are all set when you are ready, Mr. Bergman.
Okay. I'm a little technically.
Well, the good news is we can see you and we can hear you.
Okay, here we go. That's the good news. May it please the court, my name is Richard Bergman. I am here with Harrison Bergman. We represent the appellant, who I will refer to as Saber in my arguments. I will also refer to the appellee as the association. Your Honor, I'd like to reserve 5 minutes for rebuttal. And before I forget, it was a very long brief within the time allotment. I'm not going to be able to argue every single point, but I do not want it to appear that my lack of argument means that I am abandoning any of the points in my
Mr.
brief.
Bergman, just so you know, I know you have. I don't recall you appearing in front of me. I don't know if you've appeared in our court. You know, we do read the briefs and the record ahead of time, so you feel free to tailor your arguments as you see fit. But we will not deem you as having waived anything.
Thank you, Your Honor, and it is my first time of having the honor to appear before any of you judges. So it is an honor, and I appreciate it.
Mr. Bergman, do you mind if I just get right to the point?
Sure.
Okay, so we have this contract to buy a golf course, and we have a right of first refusal. And so a buyer presents themselves, wants to buy the golf course, gives the notice to the holder of the right of first refusal, and says, you got, I think it was 20 days or whatever it was to do what you got to do. And a contract is presented by the holder of the right of first refusal. It does not appear to be a mirror image of the offer, but what it appears to be is what the essence of the offer was. So in reality, what they do is they take the $1.5 million purchase price, which included this $300,000 advisory fee, which looks like a finder's fee or a real estate commission, which would have been payable somebody who doesn't hold a real estate license. So it's not only was it waivable, probably wasn't a legal fee. And so the holder of the right of first refusal makes an offer for $1.2 million, which is really the essence of what the other offer was from a legal standpoint. And the trial judge went with that. And you're here because you say, no, that's not right, that's not fair, they didn't do it. So why can't you do that?
Well, Florida law says you can't do that, Your Honor.
Well, Florida law says that in order to exercise a right of first refusal, the person exercising the right must meet the offer exactly. And what this trial court did is said, well, they basically met the essence of the offer exactly, but they didn't meet the terms exactly the way they're written out. But they cut to the chase and basically said it really isn't, you know, that $300,000 was a poison pill. It really wasn't a legal part of the price. And we're going to basically offer what the price really was. Courts aren't allowed to be practical and look at the essence of the real bottom line and say, hey, this is what's really going on here. We're stuck with, you know, sort of a, you know, we got to jump through this hoop even though it makes no sense type argument.
Well, courts are in this state, and as held by the second DCA, courts are confined to the contracts or documents which are unambiguous and clear. What this judge did was he took your logical belief and said, I'm going to rewrite the Saber contract. And I'm
focus on the 300 grand. How is that going to be paid? It clearly was a finder's fee or a real estate fee to someone clearly who's not licensed to receive that. It violates the law.
That was not tried, Your Honor, in the lower court. It wasn't.
That issue never came up?
The issue came up with Mr. Menzies, my learned opponent, making that argument, but we're getting way past the fact of the testimony of what was of record. And the testimony is that Ms. Lucchine the principal of the seller, Alagold, and Mr. Klinger, the principal of Sabre, negotiated a contract, arm's length, voluntary contract, which was later put onto paper by Mr. Klinger's attorney and Ms. Lushine's attorney, which happened to be Mr. Mann, who is the same exact attorney law firm that prepared the amended 8.5 of the declaration. The amended 8.5 of the declaration is clear on its face. It says that once a proposed contract, excuse me, is received by the association had a one-time only right of first refusal to submit a purchase contract at the same price and on the same terms as the proposed sales contract. The
Other
word,
than the price, you dispute that the price was the same. Wasn't there an issue about the deposit as well?
yes, there was, Your Honor.
Okay.
And
So there was a $400,000 deposit on the original contract, but on the right of first refusal contract, there was initially 100,000 down with the balance to be paid at the end of the inspection period, right?
that is correct, Your Honor. And there was also another major change. The testimony in this case from Mr. Weidenbrock, who represented the association, stated that he requested the Sabre contract in Word. And what he did was he took the Sabre contract and he deleted paragraph 2 of the addendum completely. And he also changed a portion of the standard contract when it came to the deposit and the purchase price. There were things in the addendum, paragraph 2, that were in addition to the $300,000 fee. For example, the first line of the addendum, paragraph 2, said the purchase price is 1.5 million, which corresponds to the first page of the standard contract. The purchase price was $1.5 million. The only party that could have determined at some point in time between Sabre and Alagold would be Alagold at the closing saying, you know, I'm not going to pay that $300,000. The testimony in this case was that Mr. Klinger said, when asked, what was the purchase price? He said $1.5 million. What were you prepared to pay at closing? $1.5 million. The contract also contained a provision.
But
And-
hang on, let me stop you there, Mr. Berger, because I'm going to ask this question. Even though the $1.5 million was there, which included this 300,000, which could be waived, might or might not have been illegal. I mean, but you say was not raised below, which I don't know, I'm not sure about that. But in the essence, though, that the seller of the property under any scenario was only getting 1.2?
Yes.
Because even if the 300,000 was paid, it wasn't going to the seller. It was going to somebody else, some other entity, right?
The net,
So at the end of the day, the only thing the seller was gonna get under this contract was the 1.2, no matter what happened with the 300,000, waived, legal, illegal, whatever happened,
I
right?
agree with you, Judge Morris, entirely. The net to the seller would have been $1.2 million less the customary closing costs for stamps and things like that.
Right. And then wasn't the right of first refusal offer at the end of the day, the exact same amount that was going to the seller?
At the end of the day, the seller would have received $1.2 million, but
Okay.
we're
So the
skipping.
essence is, while the form didn't look the same, the bottom line, what was going to happen was identical, wasn't it?
The bottom line was to some extent identical. That is correct.
Okay, tell me the extent that it wasn't.
Alagold, the deposit wasn't the same, number one.
Well, at closing, walking away from closing,
At closing,
1.2 less expenses under both contracts that seller's getting, right?
that is correct, Your Honor, except for the fact that Alagold would be placed in the jeopardy of a lawsuit by the company that was noted in the addendum to receive a $300,000 fee. Aligold would have defended that. And I don't know, I can't predict what would have happened in that case. So in reality, Aligold could have been facing a $300,000 issue by merely saying, okay, I'm going to go with $1.2 million instead of the $1.5 million. In this
Mr.
state,
Bergman.
yes, sir.
Oh, sorry, I didn't mean to cut you off. I do want to know, I'd like your thoughts on what do you believe in this case materially distinguishes it from our April 1st decision in Acquisition Trust versus Laurel Pine Brook?
Okay, thank you, Your Honor. I was going to anticipate Mr. Menzies bringing that up in his argument, and that was what my 5 minutes in rebuttal was for, but I'm happy to address it right now. You have two different scenarios. I'm sure it will not surprise you that I'm a big fan of Judge Atkinson's dissent in that 2-to-1 ruling. In the acquisition trust case, there was a situation where a letter of intent was the linchpin of the exercise of a right of first review of the contract. In the acquisition trust case, the parties had the right to make modifications and extensions after contracting. So we had a situation where the proposed buyer entered into a letter of intent, which was non-binding, and it gave an outline of the terms of what would go into a contract. Subsequently, there was a contract entered into, and then the holder of the right of first refusal only had to send out an intention email that I'm going to exercise my rights in a contract that's similar to that was offered by the proposed purchaser. Now, what happened after the fact is that the right of first refusal party and the seller subsequently modified the agreement to have different terms. In our case, we have a situation where the 8.5 as amended says clearly that for the association to exercise its right, it must, the word must, enter into a binding sales agreement with the seller for the purchase of the golf course no later than 20 days. Prior to that, we had the language same and same, which had modified the original declaration, which had the word substantially. And in response to Judge Morris, there's a big difference between substantially and the same. And this law in this state requires the courts to look at the intent of the drafter of the instrument when reading the instrument to determine whether or not it was ambiguous or in the need of some sort of modification. The trial court in our case had no right to make any sort of modification because there is nothing ambiguous in the amended 8.5. In fact, Ms. Lucien testified at trial. She was a witness to the amended 8.5 and also the wife of the deceased declarant that the reason for the change.
So I don't mean to cut you off as you're talking about what would be parallel evidence, but let's just look at the words for a second. All right. And please understand my question is with respect to the Laurel Pine Brook case and the holding. All right. It looks to me like the operative language here is simply that the community association is granted this one-time right of first refusal. And if the community association decides to exercise this right, then it must go on and enter into this latter agreement. But the exercise of the right is the key point, which determines whether or not your client has standing to object. This term 8.5 doesn't really tell you how you exercise the right, and that was the whole point of the Laurel Pinebrook case, or at least for the majority holding. Judge Atkinson construed those two together. The majority said, no, those are discrete points. The exercise of the right is one thing. The ultimate contract that is entered into later is a separate issue. Here, all the language that you're talking about, the must enter into, all pertains to the latter point, not the former, which is the framework that the Laurel Pinebrook case sets up. So help me understand what in section 8.5 hinges the exercise of the right to anything other than communicating, we want to exercise the right.
The clear language of 8.5 says, if the community association decides to exercise this right and purchase the golf course from the owner, the price and terms of the purchase will be determined by the proposed sales contract, and the community association must enter into a binding sales agreement with the seller for the purchase of the property in 20 days.
Let me try to unpack it a little, because I don't think I did a good job of explaining what my question was. What in that text tells you that text is kind of a classic if then, and all the stuff that you are talking about pertains to the then part. The Laurel Pinebrook case says, now right of first refusal, you really need to look at the if part. Is there anything that hinges on that qualifies or caveats the if part? Is there anything here that does?
And Mr. Bergman, before you answer, you've got your 5 minutes for rebuttal. So answer the question, but then you'll start eating into that rebuttal time.
Yes, thank you, Your Honor. The Laurel Pinebrook case has it's basically holds in the majority that once the party with the right of first refusal exercises its right, the party who entered into the proposed contract loses its rights at that point in time. That's what it basically says. The first 5 sections of the Laurel Pinebrook decision corresponds with our brief. It is at point 6 of the issue, which really relates to a standing argument. Does the offering party have standing to contest the proper exercise of a right of first refusal? And our position is that in this case, the trial court had to rewrite 2 items in order to shoehorn the association's exercise of the right of first refusal, thereby cutting off Saber's rights to purchase. I am absolutely on par with the thought that had the association submitted the exact contract as the Saber contract, Saber would have no further rights involving this golf course. And if the association and Alagold subsequently, for whatever reason, decided to amend the contract in good faith, Saber would also not have the right to contest that. But here the issue is, did the association properly exercise its right of first refusal, thereby cutting off Saber's rights to contest? If there are no further questions, I would like to have the rebuttal time.
Very good, Mr.
Whatever's left. Thank you.
Mr. Menzies?
Thank you, Your Honor. Good morning. May it please the court. I'm Robert Menzies. I represented the association at trial in the case. And the court's questions go right to the heart of my argument that I
Can
set
I ask
forth.
you one though that goes even further to the heart? You know, I like to kind of jump in and focus a
Yes,
little
Your
bit. Do
Honor.
you mind?
No, sir.
Here's my worry. On October 25th of 2019, Don Griffin resigned as the association's president. On October 26th of 19, the association members voted to exercise the association's right of first refusal. So at the time Griffin signed the contract, it appears he was no longer president. Am I right about that?
No, Your Honor. At the time he signed the contract, it was before he resigned on the 25th. He signed the contract on the 24th or 25th.
But the
Resigned
members
later that
hadn't
afternoon.
approved his ability to do that, right?
Pardon me, Your Honor?
The membership of the association had not approved his ability. Can he sign it on his own? He doesn't need their approval?
He had the votes that had already been submitted by the various community associations that would approve they were simply
So-
gathering the votes on Saturday, the 26th.
Okay, so that was basically a formality. Is that what you're saying?
Correct. It was the formal meeting of all the members of the community at
Yeah.
which the votes of the various community associations would be submitted.
Now, there was one community that the vote count was been challenged. It didn't have sufficient votes.
That's correct.
Right.
There was that argument that was made. And my brief, I'm simply saying the only party you could argue about that would be a member of the association. And Saber's not a member. Allegold's
Okay.
not a member. They had no standing to make that argument.
Okay, take it from there.
Yes, Ron, thank you. Going back to the questions that Judge Morris, that Your Honor asked at the beginning, the essence is really what we're talking about here. The proper exercise is distinct from of the right of first refusal is distinct from the contract between the association and Allegold. Once there's been a proper exercise, Saber's rights are extinguished. The lawyer for Allegold communicated the Saber offer to the association's counsel. They immediately began discussing the $300,000 quote advisory fee, the poison pill.
Now, you've
The
heard Mr.
associ-
Bergman say that issue really wasn't raised below the legality of it.
Right. Well, that's not accurate, because on direct examination of Mr. Klinger, Mr. Bergman's client, I asked him, "Are you a real estate broker?" No. Is Saber Real Estate Advisory a broker? No. Is Saber Real Estate, the appellant, a broker? The answer was no. I asked Ms. Lucchine on direct examination, "Were you paying a commission, the $300,000, to Saber?" She said she was. I argued at trial and in closing that the $300,000 was a poison pill, that it was an illegal commission, and it was properly disregarded by everybody, which is why we get to the net of the association agreeing from the first to pay 1.2 million, which is exactly what the seller was going to get no matter who bought the property. But the association wasn't going to pay a commission to somebody that was completely unrelated to the transaction. And that's why it was completely disregarded from the beginning. My contention is that if we look at the proper exercise issue first, the association immediately responded to the notice of the Saber contract and negotiated a contract which met the essence of the Saber contract.
And what's your best case, your best authority for us to do that, to go to the essence, not the actual,
Sure.
formality?
The Coastal Bay case is cited in our briefs, and Mr. Bergman's brief cites it as well. It requires a good faith offer and of a third party that it's matched when the essential terms are identical. That's the language from the Coastal Bay case. And I'm saying that it's my position that the offer was matched because the essential terms were identical. Not only the purchase price, but the deposit. I recognize freely that the association was not putting $400,000 down at the beginning, only 100, and that the 300 came later. But at the essence of the deposit is it was non-refundable for both parties when the due diligence period was over. Those are the primary differences in the contract between Saber's
But is that a
contract. It's
I
not a
mean,
difference, Ron. I
Yeah, yeah, I mean,
shouldn't.
if they're both non-refundable once the inspection period's over, what does
It's
it
this-
matter? You know?
It's the same $400,000. So I'm saying the essence is that is the same, and the price is the same.
Well, here's one way it matters. If there's a breach of the contract before the inspection period's over, only $100,000 has been paid under one contract, and the other is $400,000, and that can affect how the parties decide to go forward.
Actually, Your Honor, and that's not the case. Until the due diligence period was expired, all the deposits were refundable, entirely
No,
refundable.
no, I heard you say that. Refundable is one thing. Saying, yeah,
Oh,
if
I
you want
see.
me to refund it, I'll see you in court.
Right. I acknowledge that difference. I do. The Coastal Bay case, to answer your question, where the offer matches the essential terms. One of the things that I wanted to mention is in Coastal Bay and Castelli, I believe maybe an acquisition trust as well, the courts preface the discussion of the offer by requiring a good faith offer. And I submit that this was not a good faith offer. Mr. Klinger had another company that was going to get $300,000, and they weren't even involved in the transaction. And I submit that.
But why do you think it was in there? I mean, and I'm asking for your interpretation of the facts in this case. I mean, you know,
I think it
I'm not
was in
asking
there.
you to go outside the record. I'm asking you to go inside the record and interpret the facts as you see them. Why was that 300 grand in there?
Mr. Klinger, who's the principal of Sabre, was on the board of trustees of the association, was intimately aware of the section 8.5, the right of first refusal. He did it, I believe, I interpret it, I believe it was done deliberately to run up the price that the association would have to pay, to be in excess of what he was really going to pay. Because if 1.5 million came into the transaction, his other company was getting the 300,000. If the association was forced to pay 1.5 million, he was going to get that money. I think that's why it was done, Your Honor. And that's why I contend that the offer was not made in good faith. The lawyers for the parties immediately moved to negotiate. Mr. Weidenbrook and Mr. Mann immediately moved ahead with negotiations. And I contend that those communications and letters represented the exercise of the right. To Judge Lucas's point, that is distinct from the, and Acquisition Trust says this as well, the exercise of the right is distinct from the performance of the contract. In this case, we've been discussing the fact, Mr. Bergman will in his brief, highlights that they're not the same, but we've been discussing the essence. I contend that the exercise was done properly, and that the contract, even before we get to the performance part, the essence was the same. But even if it wasn't, once the exercise was proper, the parties had the right to modify their contract if they want to. In this case, they didn't, but the exercise was proper in the first place. It was muddled somewhat because the lawyers had to discuss the advisory fee. I contend that once the exercise was done, that Sabre's rights were extinguished. They had no standing to discuss what the association and Allegold proceeded to do with their contract. And one of the other points I wanted to make about the $300,000 advisory fee, both contracts provided a clause that said that if there was something illegal in the contract, that would be disregarded. Well, that's exactly what the lawyers for the association and Allegold did. They disregarded it to thus get to the $1.2 million.
Mr. Menzies, did the trial court make a determination as to the good faith nature of the offer by Sabre?
No, Your Honor, the court in the judgment did not. What Judge Kyle did during the trial was he examined Mr. Weidenbrook, because Mr. Weidenbrook is the lawyer for the association, the transactional lawyer, and he asked him to explain the poison pill. And Mr. Weidenbrook did that for the court. The court did not rule in the judgment with respect to the illegal nature of the $300,000, although it was argued and there was testimony in the record.
And my recollection is the judge did not make any finding relating to the good faith or lack of good faith.
That's correct, Your Honor. I believe that's correct. He did not. The judge simply moved through the implication in the judgment is that he ruled that the association properly exercised and moved ahead with its transaction, thereby rendering moot the Sabre contract in its entirety, and finding that Algold should have signed the contract that was negotiated with the association as provided in section 8.5.
The difficulty with that particular issue is because the trial court didn't say anything at trial and didn't make a finding in the judgment, then we are left with the question of, was the acceptance on equivalent terms? And I understand your argument is, of course, they're equivalent because the 1.2 ends up being the same net, but the 300,000 is still floating out there as to whether that is a valid part of the initial offer by Sabre or was not a valid part.
I understand, Your Honor, and I can only surmise, and that would I'm by implication, the court disregarded the $300,000 precisely because the lawyers for the parties disregarded the $300,000.
Well,
Sabre's
the lawyer for the association and the developer, not the lawyer for Sabre.
That's correct. That's correct, Your Honor.
That's a pretty significant difference.
True, true. But the $300,000 was not going to a party to the transaction, which is another reason why it was disregarded by the parties, Algold and the association. I understand Mr. Bergman has another client that was supposed to get some money here and they didn't.
Well, and I recognize the legality of a brokerage fee is controlled by statutes, but there are clearly transactions where there are finder's fees or consulting fees or all sorts of things that are done, but they're typically done outside of the purchase contract. Although I have a vague recollection that I've seen some where it's actually in the purchase contract, but it's specified in some way that it's clear what it's for. And we don't really have that here. We just have pay $300,000 as I think it was an advisory fee, if I recall.
Correct, correct. The direct testimony that, other than the written document, that's it's called an advisory fee in the Sabre contract. I asked Ms. Lucine, who's the principal of Algold, if she was paying a commission, the $300,000 was a commission. She said it was. So that's her understanding of what was going on.
To the extent that it was a real estate commission, the brokerage, such as it might be, was not a party to the contract. Is that correct?
Correct. There was no licensed broker or party to the contract. Neither of the Sabre entities is a broker.
The other Sabre entity that is not a broker did not execute the contract.
That's correct, Your Honor. That's correct. I'm almost up with my time. Going back to the acquisition trust, I think it's directly on point. And the important part of that case is that it does not conflate the two concepts, exercise of the right with the contract itself. And here we have a proper exercise, and therefore Sabre's rights were cut off.
The acquisition trust apply in a situation where there is a claim of bad faith between some sort of conspiring to get a higher price to see what the market will bear, but then the association and the developer, they really want to keep it within the association's control. Would that be something that acquisition trust deals with?
It doesn't deal with it specifically that I'm aware of, Your Honor.
In a situation like that, the third-party purchaser or the third-party offeror would have a claim against clearly the developer. There'd be a claim, and possibly the association as well. Do we have any of that here?
No, Your Honor. There is not anything like that in the record at all.
And we have a deck action and specific performance there. And if I remember correctly, the allegations were basically the terms of the offer were not the same. Therefore, it's an invalid exercise of the right of first refusal.
Correct. Saber argued, and as you can see from the brief, that Webster's dictionary, same means same, and that was the primary basis of the argument. Not that there was any fraud or conspiracy to do anything on the part of Allegold or the association. And the association sued, saying for specific performance, saying we have a contract, let's go with it, and for a declaratory judgment. And then Saber brought a cross claim as well against all parties. With that, I think that the judgment should be affirmed. It's fair, and to Judge Morris's comments at the beginning, that's the essence of my argument, is that the contract was essentially met the terms of the right of first refusal, and it was appropriate to move forward with it. And Allegold did not, basically, I assume because they were being threatened by Saber, and the court ruled that they should have, and found that the association was a prevailing party and should proceed to purchase the property. I'll stop there if there are no other questions.
Very good. Thank you, Mr. Menzies. Mr.
Thank you.
Yes, Your Honor. Few points in rebuttal. First of all, Mr. Menzies mentioned the illegality of the advisory fee. The contract says clearly that if a clause is found to be illegal or unenforceable or void, that is stricken from the contract, and the contract proceeds forward with the rest of the terms. The purchase price,
In which case, it would be the
1.5
million.
million. I'm sorry, I can't hear you.
In which case it would be the $1.2 million. And so the only real discrepancy at that point would be whether the deposit amount was a same or sufficiently similar term.
I disagree respectfully, Judge Silverman. In that case, the purchase price on the Saber contract is 1.5 million. The purchase price within the addendum is 1.5 million. So let's assume
Is the advisory fee, if it is deemed to be an illegal brokerage commission, it would simply convert to more of the purchase price?
that is correct, Your Honor, and that is
Even though the contract specifies that the purchaser would never be paying that amount to the seller.
Your Honor, the testimony at trial with respect to that very issue was, what were you prepared to pay? 1.5 million. If there was no advisory fee.
But that's not what the contract says. The contract says basically a 1.5 million purchase price, except 300,000 is going to come out of that transaction as this advisory fee. So if it's an illegal advisory fee, why does Saber get to get $1.5 million that it was not going to end up with, the purchaser was not going to end up with as part of the contract?
I think, Your Honor, you're saying, why would the seller, Allegold, get $1.5 million?
Yes.
Why would the seller profit?
Right.
That was raised to Mr. Klinger, and Mr. Klinger accepted the fact that he was paying 1.5.
Well, but he's testifying about what a contract says, and while we certainly are interested in what he thinks, if the contract says something different than what he testifies to, of course, we have to rely on the contract, right?
Of course, Your Honor, but the contract isn't different than what I'm saying. The
But
contract purchase price is $1.5 million.
That fee is illegal. Wouldn't the ultimate order be the purchaser does not have to pay that $300,000 because that's an illegal term in the contract?
If the purchase price, Your Honor, I mean, I guess we're passing.
I think I understand. Your position is the $1.5 million is going to be paid,
No
and
matter what.
no matter what.
No matter
And
what.
neither Saber entity would get it, but the seller would get to keep that extra 300.
Yes, Judge Morris
Okay.
Judge Morris answered that for me. Thank you. Because I wasn't making myself clear. 1.5. Now, just briefly addressing Judge Lucas's and the theory of the essence of a contract, and I believe Judge Morris also mentioned essence. During Mr. Menzies' argument, I reread the the acquisition trust case, I don't see the word essence in there at all. In fact, what I see, again, and I'm repeating myself, is the reasoned decision of the majority goes through the law of the state as well as the law of the second DCA as to what a right of first refusal is, what the terms of a first refusal need to be. All of that is contained therein. The issue here, and it's clearly set forth in Mr. Menzies' table of contents and in our brief, and the argument that has brought us before your honors, is whether or not in this case, based upon the amended section 8.5, whether or not there was wiggle room for the trial judge to look at the essence rather than the written word.
And Mr. Bergman, you're almost out of time. You've got about 30 seconds left.
Okay, for those reasons, Your Honor, we believe the trial judge abused his discretion, that the judgment should be reversed with instructions